Now, turning to the meaning and purpose of a popular initiative under Article 257 and its constitutional remit. Article 257 of the Constitution provides for an amendment by a popular initiative. I've quoted that section, but I'll not read. In addressing the power to amend the Constitution through a popular initiative under Article 257, the first question that arises is, what is an initiative, and who is a promoter in regard to a bill under this article? The High Court was criticized for relying on the definition from Wikipedia, a free online encyclopedia created and edited by volunteers. On my part, I have sourced the definition from Black's Law Dictionary, 11th edition, in which initiative has been defined. And that definition, which I will not read in the interest of time, that definition concurs with the Wikipedia definition which the High Court adopted. So, in other words, their reliance on Wikipedia was inconsequential. From the above definition, it is apparent that an initiative is a process through which voters take control by compelling a vote on a specific legislation. This means that the process must be a process initiated by a voter or voters as opposed to their representative. The definition is consistent with Article 257 that requires a promoter of the bill to galvanize support for it and establish that it is supported by at least 1 million registered voters. The definition is also consistent with Article 1, Sub-Article 2 of the Constitution that provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, I've also looked at the American equivalent of which is referred to as the American equivalent of a popular initiative, which is referred to as a constitutional initiative. And this is how Professor Albert Stern describes it. The constitutional initiative is a technique of constitutional reform which affords a means of supplementing amendment by legislative proposal. It is not intended to replace the older method of altering state constitutions, but merely to provide an instrument whereby the people acting directly may inaugurate change. It continues, but I'll not go on. Then, looking at the history, we see that in the final report of the Technical Working Group of the Constitution of Kenya Review Commission, which was quoted by the Attorney General on the historical background, it reveals the same thinking, because it was stated that the committee introduced a novel idea called popular initiative, and this is an innovation where the citizen can, on their own motion, initiate amendment to the Constitution by a way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. So the framers of the Constitution, having provided under Article 256 for a parliamentary initiative, it follows that the second avenue of a popular initiative was intended for the people and not their representatives, such as members of parliament or the president. The word promoter has been used in Article 257, 3 and 4, where the promoter is obligated, respectively, to formulate a general suggestion into a draft bill and to deliver the draft bill and the 1 million supporting signature to IEBC. Black's Law Dictionary has defined a promoter, and I have quoted that definition. And using that definition, a promoter of a popular initiative under Article 257(3) may not necessarily be the originator of the idea of a popular initiative, but one who takes the lead in putting the idea together in the form of a bill and encouraging other voters to support the idea. In line with the objective of a popular initiative, such a promoter must be an ordinary citizen and not a parliamentarian or a state officer. So my finding on the popular initiative is that I concur with the learned judges of the High Court that a popular initiative is an initiative of the ordinary citizenry as opposed to the law-making bodies, and that it is intended to be used where the law-making bodies are unable or unwilling to act. Neither the President nor any state organ can initiate an amendment through a popular initiative under Article 257. Another issue is whether constitutional amendment through popular initiative calls for public participation. This one, I will not go into it. I think it has already been discussed. The issues and the arguments have been made by my other colleagues, my brother and sister judges who have already given their judgments. And indeed, I come to the same conclusion that there must be participation, and not just participation, there must be meaningful participation. So I'm in agreement with the learned judges that public participation is one of the principles of good governance, and that it's a constitutional right that must be complied with at every stage of a constitutional amendment process. And in particular, I have said that it's particularly crucial at the commencement of a popular initiative, because the people must have appropriate information regarding the initiative to enable them make an informed choice on whether to support the bill or not, on whether to support the initiative or not. And therefore, the adequacy of public participation at the outset is very crucial. For if the people are not well informed and properly engaged, then the initiative cannot be a citizen process. One other issue with regard to participation, the appellants argued that it was for the respondent who are alleging that there was no public participation to prove this fact. However, under Section 112 of the Evidence Act, it is provided that in civil proceedings, when any fact is especially within the knowledge of any party to those proceedings, the burden of proving or disproving that fact is upon that party. If there was public participation carried out in regard to the popular initiative, this was a fact that was within the special knowledge of the appellants who are promoting the Amendment Bill 2020. The appellants cannot therefore shift the blame onto the respondents to prove the fact of public participation. No evidence was laid before the court to prove that there was any meaningful public participation before the collection of signatures in support of the proposed constitutional amendments. And I therefore uphold the finding of the learned judges that the BBI Steering Committee, as a promoter of Kenya Constitutional Amendment Bill, failed to comply with the key constitutional requirement of giving people information and sensitizing them prior to the collection of signature, and this rendered the process constitutionally unsustainable. With regard to the procedure in the county assemblies and parliament, it has already been referred to by my colleagues.